Hey y'all, Eli here from Mile High Pokemon. As many of you know, Rattle recently got sued. He made a video about it. And as many of you know, I'm an attorney, a lawyer. Not your attorney, but just generally am one. So I decided to go through parts of the lawsuit for those interested to talk about the process, sort of how it works, and the claims being made against him. So before I get into it, I first want to talk about, disclaimers first. So as I said, I'm a lawyer, but I'm not Rattle's lawyer, and I'm not your lawyer. So what I'm talking about today is purely for educational purposes. It's based off background knowledge and some limited research. I might be wrong. I don't know Canadian law almost at all. And Arizona law, I know to the extent that I researched law in other areas or in other states, but I don't know Arizona specific law that well either. So take everything I say with a grain of salt. I know general constitutional principles fairly well, but this is not legal advice for anybody, okay? I also want to point out that I'm not on anyone's side. I'm not on one side or the other. I'm just trying to talk about the law as it exists and the way it'll be applied. Personally, though, I am a strong proponent of free speech in many contexts. I also want to talk about the fact that the views I give are my own, not those of my employers, and I'm only discussing some parts of the case today, not everything. There's too much to get in one video. So today I'm talking about the procedure, which is what happens next in the suit, what are the basics, jurisdiction, can a Canadian get sued in Arizona, what does that look like, SLAP suits and AntiSlaP Laws, which are pretty much when you file a suit against someone to silence them illegally, or not illegally, but impermissibly, libel, what it is, when does it apply, and then, leave any comments on questions that you have. So let's first talk about process. So the first part of lawsuit is you file a complaint. You say pretty much everything, whatever, that you did wrong or the other person did wrong, what laws they broke or what violations, what torts they committed, etc. And then you have to serve the other party. From my understanding, Rattle was probably properly served, but usually internationally use the Hague Convention, which is either mailing it to the person if the country allows, or many countries, it's just like here in America, where pretty much you have a person of the government or you hire a company to hand deliver the thing and get a signature to ensure it was accepted. That's in order to provide people notice, because you can't really sue someone who doesn't know they're being sued. That's what process is for. So usually what happens then is you have either a motion to dismiss or an answer. Sometimes they go in different orders. An answer is pretty much where you go like line by line and say, yes, this happened, no, this didn't happen, or give your version of events. So for example, here we have a few claims. Like one of them is Neopets is a virtual pet website. Users can own virtual pets and buy virtual items for Neopoints. They're virtual in-game currency, right? So like when you respond to that one, you'd probably be like, yeah, that's true. I accept that as fact. Whereas here, number 42, Baristo called Basak from private numbers many times. Basak believes initial contact to have been sometime in August 2023. So in that case, you'd respond and be like, yes, I called them many times. The first time I called them was X. Or this is false and I never called them, which, whatever. So you sort of go line by line. And then usually you file a motion to dismiss. And at the anti-SLAP stage, in the states where you have a law, this gets taken sort of seriously, and I'll talk about that later. But essentially in a motion to dismiss, you accept everything is true in the complaint. So we presume everything that was put here is true. Does he still have a lawsuit? Can he still, even if everything as it is written is true, is that still a violation of the law, or is that still something that you can recover from? Because frequently people will write complaints, and then the judge will look at it and say, okay, well, even if everything here is true, like the other person didn't do anything wrong, or like you don't have recourse or whatever, or this wasn't specific enough upon which you could get relief. So that's usually what happens at the motion to dismiss stage. So in terms of personal jurisdiction, you can't just sue someone who's never been to a state, generally. Because we, in our Constitution in America, have this idea of due process, and it's just like simply unfair to sue someone when they have no contact with the state if they've never been there. Generally, if you've been in a state, there is personal jurisdiction, or if you get served there. But otherwise, you need what's called minimum contacts. So for a Canadian to be brought to be sued in Arizona, for example, Essentially, you'd need to establish three things: that the person committed an intentional act, expressly aimed at the forum state, causing harm that the defendant knows is likely to be suffered in the forum state. This is a very, I think, big gray area in the internet era, and a lot of it's still being worked out. I have this case here, for example, I cited where there was a Canadian YouTube creator who may have committed copyright infringement, but they ruled that there was no minimum contacts with the state because his YouTube video was just posted generically on YouTube. It wasn't specifically targeted at California, and so there was no personal jurisdiction. I think it's difficult if you have a case like Rattle's here, right? On one hand, his video is on YouTube. It's not targeted at a specific state. It is sort of targeted to the world for everyone, nowhere specific. And there isn't like a benefit he's trying to avail himself of from Arizona, for example, like selling a product there or something, right? But on the other hand, he does have a target in terms of like a person, right, being targeted. And if there were, for example, someone who made a YouTube video, not Rattle, but analogous situation, to commit libel and actually hurt someone's reputation in the state in which they live, then maybe a court could find that there is sufficient personal jurisdiction. So I think this question is a really hard one. It's not necessarily a clear answer, but I think there are arguments to be made to both sides. I would lean on the fact that there not being personal jurisdiction, unless there were other steps that I don't know that Rattle took to create a relationship with Arizona. The other thing I want to mention as a disclaimer is I have not watched all the videos in dispute. I've watched some of them and parts of many of them. But I'm just basically, at this point, going off the complaint and what the allegations are against Rattle. So there are things that I might be missing. So, for example, if I'm like, I think the case here is a weak one or whatnot, right? I haven't watched all the videos. So maybe like minute 54 of one of his videos, and I only watched a minute 45. Maybe he says something, right, that it makes him liable that I just haven't seen yet. So I don't have a fully informed view in that respect either. So I wanted to make that clear. So one of the things you do if you're sued in state court and you're an out-of-state resident is you try to get into federal court. So generally you can't get into federal court if you have two people from the same state. But if you're an out-of-state defendant, and the amount in controversy is over $75,000, like here, usually your attorney is going to try to get you into federal court. The reason this works this way is because there's this idea that there might be like in-state bias in state courts. So for example, if like there might be favoritism towards their own residents or something, that's like the original idea. So you can get into federal court. The actual tangible benefits of getting into federal court is that frequently, the judges in federal court are going to be have more experience, have dealt with specialty cases like libel. Like libel isn't something that you deal with frequently or commonly. Drunk driving is something that judges deal with all the time. Breach of contract is something judges deal with all the time at the state level. But libel is less common. And so if you're trying to look for a judge that really knows what they're doing, you might have better luck in federal district court than you do in a state trial court. So that might be another reason to go. And it's more predictable. The rules are more established at the federal level in terms of like they're standardized across the country, right? So there are reasons to go to federal court. There's also this question of choice of law, and this is something I really don't know very much about at all. But frequently, you can have a court in one state apply the law of a different state. This usually happens in contract. For example, if I make a contract and I live in one state, I don't know, if I live in Colorado and I make a contract with someone who lives in New York, we're allowed to say in our contract that we're going to use the law of California. Even though neither of us lives there, we can put in our contract that we're going to use the law of California to resolve our dispute. And then we would go to a court in Colorado or in New York, and that court in one of those states would apply the law of California. And so one of the things that I think might happen here, but I'm not sure about because I just don't know enough about this specific thing, is that potentially you could see a scenario where someone's trying to get Canada's law or the law of Rattle's province applied in Arizona by that judge. I don't know how that works that well, but I think it's potentially something that could happen. So today I'm just, there's several things in the complaint. There's 5 things, 4 charges, and a request for a preliminary injunction. I'm only going to talk about one of the allegations, one of the claims today. This is the biggest one, I would say probably the most important, because it's, I don't know, it's sort of the one that's the most glamorous. So we're going to talk about libel, right? Libel, slander, they're sort of the same thing. One's published, one's spoken. But there are several elements. And what are elements? Those are the things that you have to prove in order to succeed. So if a crime, for example, has 4 elements, the government has to prove that you did each of those 4 things in order to convict you of a crime. So libel has several elements as well. So the first element is that any false statement has to be one of fact, not opinion. So for example, if Rattle called Sean a, quote, wiener baby or a, quote, rich bitch, that is an opinion. That is not a fact. So you can't get, you essentially don't have recourse for that under libel law. Similarly, if you say that someone's selling junk slabs, that also, to me, seems like an opinion. Also, if there are certain facts that then lead to you suggesting a hypothesis, like, oh, I see this and I see that and the other thing. I think this thing happened, or I believe that this was bad, right? Those are all opinions. So you can't be held liable for that under libel. Here, the main allegations, it looked like when I read the complaint, is Sean is alleging that he was unfairly or wrongly, incorrectly accused of the scheme regarding the uncut sheets and those sales, sort of insider trading with CGC, knowing ahead of time that about the 9.5s and buying them up and selling them as 10s, and then the Charizard wheel scandal, right? Those are the sort of the 3 claims, right? So theoretically, if, let's say, Rattle had lied about that, those are sorts of the false statements that we're looking for about a plaintiff. So that's the first element. Second element is that the statement is to be defamatory. So to be defamatory, it must be false. It must bring the famed person, into disrepute, contempt, or ridicule, or must impeach their honesty, integrity, virtue, whatever. So, if the statement is false, but it is not defamatory, in the sense that, like, I don't know, if I said that Rattle owned 5 cats and I'd lied, that is not defamation, because it doesn't meet these, like, ridicule, contempt, whatever, right? Third element, it must be published, which means, YouTube, whatever, that counts, so that one's easy. And the fifth element is damages. So there must be some sort of harm incurred as a result of the speech, right? Now, if you're paying attention here and counting, we're missing an element. The fourth element, which is mens rea, which means what is your level of intent? Normally, in most criminal contexts, there's 4 types of mens rea, which is like how guilty do you have to be, essentially, to get in trouble. The first is intent, which means I intended to go do something. Like for battery or assault, it would be like I intended to hit that person if I wanted to show battery, right? The second tier is knowledge, which means that you know that something probably could happen, but you don't care. So, for example, if there was a law against reckless endangerment, and I went outside and I started shooting a gun in the air and bullets falling, you don't know for sure that they're going to hit someone. But you're pretty sure it will hit someone, right? Generally, you just don't know who, right? Recklessness, that might bleed into recklessness depending on the context. Recklessness is when a person consciously disregards the risks associated with a particular activity. That's like drunk driving, right? You know if you drunk drive that you might be impaired and hit someone and could hurt someone. You don't know that. You also don't intend to do that, but you're being reckless. And then negligence is when a person's conduct falls below a reasonable standard of care. That can be sort of wishy-washy depending on the context. But essentially, you didn't dot your I's and cross your T's. You weren't being careful when you were supposed to be careful. So when the plaintiff is a normal person, the mens rea you need is negligence. So what I mean by that is that if Rattle said something that was factually incorrect about someone who is a normal person, like totally rando and is not famous or anything like that, if he said something about just like a random customer that he had, whatever, or a YouTube viewer, then the standard is negligence. If he was negligent, he could be held liable for libel. That means, I don't know, if he got in a fight with a viewer and believed something about the viewer and wasn't careful about double checking that thing and made a video about the viewer, who is not famous or anything like that, right, he could be held liable under the negligence standard. However, if you're a public figure, if I say something factually incorrect about a public figure, the standard is higher. It's much more difficult to win a lawsuit. This is important, as we'll get to, because we don't know whether Sean, the plaintiff here suing Rattle, is a public figure or not. And if he's a public figure, it's going to be much more difficult for him to win. So public figures aren't just people like presidents. They're not just famous people, right? You can be a limited purpose public figure. What does that mean? That's someone who thrusts themselves to the forefront of a particular public controversy in order to influence the resolution of the issues involved. There's people that have assumed roles of special prominence in the affairs of society, someone who has invited attention or comment, right? This is because we believe generally, or the Supreme Court believes, that public figures are better equipped to defend themselves. So if I already have a large YouTube channel and I get libeled or someone says something false about me, I can defend myself because I have 1 million viewers or whatever, let's say, right? So you have less protection. Also, there's the idea that you accept the risk of thrusting yourself in the public eye. So if you have a Pokemon-related channel and someone lies or says something that isn't true about you in that context, well, you sort of put yourself in that place where that could happen. That's the idea behind it. And a public controversy, to meet that definition, it must be a real dispute, the outcome of which affects the general public or a segment of it. That doesn't mean that it has to affect everyone, but in the Pokemon community, if it affects a lot of people, that could be a public controversy, right? So there's a real question about the voluntariness, right? To what extent do you have to thrust yourself into the conflict or into the thing for you to become a limited purpose public figure? And the standard in many circuits and in a lot of states is low. So here's one from the Ninth Circuit, which is the same circuit that Arizona is in. This is about directors of a nonprofit who were essentially accused of misusing funds. And they were arguing that, well, we're not public figures. We're just we just run this organization. We never wanted to be famous. But the court said, voluntariness can be satisfied by showing that a person or entity engaged in a course of conduct that foreseeably put themselves at risk of public scrutiny with respect to a limited range of issues, which means you are acting in a position where you could be subject to public scrutiny in a narrow band of issues here, that being the nonprofit sector or whatever. And the second part here that's important is by actively seeking attention from the press, promoting themselves through social media, employing public relations staff, and soliciting donations and grants, Planet Aid and Thompson assumed a risk of public scrutiny. This is sort of the most important part of the libel claim that we have in this case. Whether Sean meets the definition of a public figure. Did they actively seek attention from the press, promote themselves through social media, in this space? If so, then the standard is much higher, because if you meet the standard, then you have to show, to win, actual malice. That means that to win the case, if he's a public figure, Sean Bassick has to show that Rattle either lied explicitly about him or had reckless disregard for the truth. Reckless disregard is defined as disregard of the truth or falsity of a defamatory statement by a person who is highly aware of its probable falsity or entertains serious doubts about its truth when there are obvious reasons to doubt the veracity and accuracy of a source. So a few things could be meet the standard. For example, if Rattle reported on a source like he had a contact and there was no reason to believe the contact actually knew what he was talking about and he published it anyway or he spoke about it anyway. Another way would be, obviously, if you knew it was false. Another way would be if something seems really like it probably isn't true based off the evidence you have and you say it anyway or you don't investigate further. That can all meet the actual malice standard. But as you can see, this is significantly more difficult to show than negligence, right? Because if you're a private citizen and someone says a lie about you or something that isn't true, under the negligence standard, you just have to show that they weren't being careful. Under the actual malice standard, you have to show that they really were meaning to lie or to really didn't care about what the truth was, right? It's sort of funny because if you read the complaint that Sean Bassick filed, he says a few things about himself. He says that His Omega Mystery Box quickly became one of the best-selling products in the category. These are direct quotes from the complaint, right? That BVC, quote, established and expanded relationships relating to professional grading, auction houses, individual sellers, sales funnels, vendors, live streaming, content creators, etc., etc. That he is an experienced entrepreneur and angel investor who has built and advised companies, and that Bassick has spent years helping industry writers, forum users, event organizations. So Sean does this because he's trying to show that he suffered a big harm, but what he actually does is show that he might be a public figure. He's saying that he's so important and so famous, which almost kills his case on the libel front. Because essentially then you're saying, well, okay, that means you have to show that Rattle knew he was lying or that he was being completely reckless disregard. And that's going to be significantly more difficult to prove. So this was a really terrible strategy, quite frankly, in terms of the portrayal. The better I think anyway, and once again, this is just my own opinion, but I think a better strategy would have been to, of course, point out the value and the business acumen and all that, but avoid saying that you're well respected and all that, or that everyone knows who you are and trying to paint that. So the best defense to libel is truth. So sometimes this can be right at the beginning of the lawsuit shown. Sometimes it has to be uncovered through discovery. For example, one of the claims that Rattle makes that Sean claims is a lie is that essentially Sean didn't have to pay ahead of time to get all those CGC slabs graded, and that there was some deal where he could pay after the fact because he couldn't have afforded to get 250,000 slabs graded at once, right? Right now, we don't really know whether that's true or not, if Rattle did say that as explicitly as that, but through discovery, theoretically, this is something you would find out, whether it's true or not. What about the disclaimer? Rattle starts a lot of his videos with this disclaimer. All statements contain error in our opinions. Opinions are held in good faith. Quite frankly, a disclaimer is good. And if you're in front of a jury, it could help you because you'll say, well, I warned everyone, I say it's my opinion, But it is not like a get out of jail free card, okay? Because if you commit libel, it doesn't matter that at the beginning you say, oh, this is just opinion. And what do I mean by this? Let's say I make a video and I'm just spewing lies about someone else, right? That they broke the law, that they're a sex pest, I don't know, whatever, right? If I at the beginning say, oh, just to let you know, this is my opinion, and then spend the next hour lying about someone, I'm not safe. That's not enough because clearly you still have the intent to do the libel. And it's not just going to save you. I mean, another example is I frequently tell people this isn't legal advice, right? You're not my client. This isn't legal advice. Here are just my opinions generally about the law. Right now, right? I'm giving you general opinions about the law. If I said, hey man, this isn't legal advice, and then I wrote your brief for you or I filed paperwork for you with the court, it doesn't matter that I was oh, this isn't legal advice, don't listen to me. I did the thing I'm not allowed to do, right? So it's not a shield. So now that we've gotten past that, I want to talk a little bit about why we have strong free speech protections in America. America, quite frankly, has the freest laws on free speech in the entire world. I personally think this is a good thing. I think the First Amendment is wonderful. In other countries, Europe, Canada, etc., they think about free speech differently, and obviously in authoritarian regimes, there is no free speech in the way that we understand it. So as a result, our libel law is very protective in the sense that it's very difficult to win a libel lawsuit, or many free speech lawsuits, it's very difficult to win because we value speech. The Supreme Court, in the case of New York Times v. Sullivan, essentially said that we need a lot of breathing room in society on the legal side, or otherwise people will have their speech chilled. What do I mean by that? Well, if you have a law that's ambiguous, or you have a law that restricts a decent amount of speech, then a lot of people are going to be afraid to even say things that are totally okay and legal, because they're not going to be sure whether what they're saying is legal or not, or whether someone's going to come after them. So as a result, in the area of libel, we have a lot of wiggle room because we don't want journalists to be afraid to report on things. We want to have, like, yes, sometimes journalists will say things that are false, but that sort of comes with the territory and comes with the risk because we want journalists to not be afraid of speaking. That is the principle, right? And then the other principle is that we live in a democracy, and to make decisions democratically, we have to talk to each other. We have to discuss issues of public concern. And if people are too afraid that they're going to get sued by discussing an important piece of news or an important like viewpoint that is related to policy, how we should run our society, whatever, they're not going to speak up, and we'll lose out on a lot of great ideas. We won't be able to decide on how we want to run our country, our state, or our communities. So this is why we are so protective in America on free speech, and that's the sort of thing that informs the way that courts interpret the law. Here. Now, briefly on anti-SLAPP laws. So in America, and this is actually not the same way it works everywhere else, essentially everyone pays for their own attorney. It's not always the case. There are some laws where that work differently and essentially allow you to recoup if you're a winner. It's rare and it's not standard. So generally you have to pay for your own lawsuit. And as a result, there are these things called SLAPPs, which Rattle talked about in his video when he talked about this lawsuit, which is essentially when rich people get mad that someone's talking bad about them, so they file suit. And then the defendant, the person who spoke, has to spend a ton of money on legal fees to protect themselves, even if they're going to win, even if they were totally right, they didn't do anything wrong, right? And the concern is that people will be afraid to speak if constantly people are threatening to sue them. This is one of the things Rattle talked about with Sean, which I don't know the exact details of the correspondence, but allegedly Sean threatens to sue people frequently. I don't know if that's true, again. But if that's the case, then it sort of demonstrates why people are afraid, right? If they're afraid of speaking the truth because they're going to get sued. So a lot of states have implemented what are called AntiSlaP laws, which essentially make it much easier to get cases thrown out much sooner that otherwise don't have merit. And second of all, it frequently allows courts to force the plaintiff to pay the attorneys of the defendant. So in a case like here, if Rattle were successful on an anti-SLAPP motion, then theoretically the court could order Sean to pay for the lawyers of Rattle. So this is supposed to punish people who file lawsuits essentially for no reason, or to use it as a tool. So I just copy and pasted here the requirements in Arizona, which is where Rattle's getting sued. Essentially, you have to file a motion to dismiss or quash within 60 days. The defendant must demonstrate that the case against them was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of their speech. Discovery isn't paused if the anti-SLAPP motion isn't responded to, but once the court decides that a prima facie, just like a initial showing is made about the anti-SLAPP, then the other party has to respond. So the big thing here, though, unfortunately, is that you're not absolutely entitled to the fees if you win and you're a defendant. It appears that under the new law in Arizona, it's up to the discretion of the court. So it's just up to the judge whether they feel like it's justified. I think in a lot of cases, a reasonable judge would decide that it is justified to award attorney's fees simply because people don't like others who file lawsuits for no reason. But that's sort of how it is. The last thing I wanted to talk about is about liability for others. So part of the complaint alleges that Rattle sort of forced his community members to, or because of him, other community members attacked Sean or his family members, made calls, whatever, right? But in America, we long have this principle that, first off, you can't be held liable for your speech unless you meet the imminent lawless action standard. What does that mean? That means that you have to sort of actively be encouraging other people to break the law. So, hey, everyone, let's go to the store and rob this thing. Right now, let's go do it, right? That would meet the Brandenburg test. But generally talking in a way, on which another person acts to do something illegal is not enough. And there's this really big case, NAACP v. Claiborne Hardware, famous case. Essentially what happened is the NAACP had a protest, a boycott, where they encouraged residents of the community, black residents, to not patronize businesses of white people, so not to go at all. And over time, it was enforced not just on the businesses themselves, but essentially there were threats made against individuals who didn't boycott. So essentially, if there was a black member of the community who chose not to boycott a white business, there were reports of threats made and even potential physical violence for not abiding by the boycott. And so the businesses or the people sued the NAACP saying, you encouraged this boycott. Look what's happening now. Like, people are getting maybe beat up or threatened, and it's all your fault. And the Supreme Court says, no, that's not how it works. As long as your speech was protected and peaceful and all that sort of stuff, you're good. It doesn't matter that other people decided to go overboard on what they did, because it would be unreasonable to hold you liable for the actions of others. That's just not how the First Amendment works. I mean, you can think about this with regular protests, because this is an issue that props up, where there'll be people that organize a protest, they go out, and then some people decide to go overboard and do riotous things, right? And break a window or whatever else, right? If we punished protest organizers for what protesters did, then essentially people would never hold a protest, right? They would be too scared to, because they would be afraid of getting held liable for what other people do. So we generally have this principle in America frequently that you can't be held liable for the actions of others if your speech was protected. So yeah, those are the main things I wanted to touch on today. I appreciate you all for watching. I know this video is probably relatively boring in terms of the content itself, but hopefully you found it enlightening. I'd really appreciate if you all could like the video if you enjoyed it, and also just feel free to leave questions below that you have about the lawsuit, about other legal issues related to the in the Pokemon sphere. I'd be happy to talk about them. Thanks all for watching, and have a good night.